All right, so I received 3 questions from the jury. The first one is, they appeared on note cards, so that I don't know what order they came in, but this is the order I got them. This is the order I'm going to read them. What is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The second, are video clips of Karen's interviews evidence? How can we consider them? And the third, does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? So I will give you some time to consult. I think the first one, I'll hear from you as to what the time frame is, and I don't need to hear from you now. That's pretty clear cut what they're looking for. The second one are video clips of Karen's interviews evidence. How can we consider them? Well, we know they are evidence, and they can give them whatever weight they want. I would also be inclined to give a humane practice instruction, and tell me if you want the digital evidence instruction. It's a little awkward because it would be something like, before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the person who appeared in the communication was in fact Karen Reed. So think about that when I come back out. But I think it's appropriate to give a humane practice instruction, and also tell me what you think about what to say about the weight. The third question is a little bit more, I think, unclear as to exactly what they're looking for. Does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? What I'm proposing, I gave you both a verdict slip where I included the language. I know yesterday I said they have to be read hand in hand, the jury instructions with the verdict slip. I've incorporated the language from the jury instruction into the verdict slip. I've given each side a copy. When I come out, I'd like your input on whether you think this is appropriate. I would instruct them, as I did before, that they start at the top and work their way down. That's the only thing I did not specifically put in here, but I think it takes it step by step, an analysis to do it. So how much time does the defense want to be able to respond to me?
Perhaps 15 minutes.
Okay. And the Commonwealth?
That will suffice.
Okay. So it's 7 past. Why don't I come out at 25 after, give you 20 minutes?
Thank you, Your Honor.
All right.
All right. So I will hear you on the first question, the time of the OUI. Any suggestions?
Your Honor, do you want to hear from the defense first?
I'll hear from whoever's. You're standing up, so I'll hear from you first.
Okay. On question number 1, what is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? Our suggestion would be something along the lines of, ladies and gentlemen of the jury, you have the evidence. It's your decision.
You are the fact finder.
You're the fact finder.
Mr. Brennan, or whomever from the Commonwealth?
My suggestion would be 12:45.
And why is that?
The case has always been focused at that time. I don't think there's anything specific in the indictment regarding the time.
Do we have the indictments?
No.
If it's not in the indictment, I'm uncomfortable telling them a time.
I'm sorry?
If it's not in the indictment, I'm uncomfortable telling them a time.
Understood.
All right.
I agree with the court on principle. I just don't have the indictment memorized, so I don't remember if we can pull that up.
There's no time? I don't expect that there's any time to be.
All right, so I'll say you have the evidence, and remember, you are the fact finders, or something to that effect. All right. Are the video clips Karen's interviews evidence? How can we consider them? So I'll tell you what I was planning on saying, then you can add to it.
Sure.
Yes, the videos are evidence. Give them whatever weight you think is appropriate to give them. And then I would give the digital evidence instruction and the humane practice instruction.
The only thing I would respectfully ask the court to include in that sentence is give them whatever weight, if any, you deem appropriate.
All right.
If any.
Okay.
Thank you. Otherwise, it's fine.
Okay. What's the Commonwealth's position?
We have a different perspective on that.
Okay.
The first part of the question, are the video clips of Karen's interviews evidence? The answer should be yes.
Okay.
How can we consider them? I think it's fair to say you should weigh the defendant's statements as you would evidence. Since they've been interviewed substantively, they are like any other piece of evidence. There's no difference, and there shouldn't be any reflection of a difference in the answer. We didn't introduce any evidence in this case and say you should give it any weight, if any at all. We didn't provide a limiting instruction in any way, and these shouldn't be so limited. This is just like a photograph. It's no different than a physical piece of evidence. And so I think the answer should simply be yes. You should weigh the defendant's statements as you would any other piece of evidence. I do not think the court should give humane practice or digital evidence. It suggests that there's some deterioration or further analysis that is different. Those instructions were already given during the charge. In addition, those instructions are in their hand in the written jury instructions. And so, to put it most simply, as I think that we should, is this is a piece of evidence, and you weigh it like you would any other piece of evidence, whatever they decide, rather than give them guidance to curtail it or to limit it in any fashion.
My only suggestion, Your Honor, is that every single piece of evidence that's provided to them, it's in keeping with Massachusetts laws, in keeping with the responsibility that they have. Every single evidence is given the weight, if any, they deem appropriate. That is not a misapplication of the law. I think the Commonwealth's suggestion suggests in the answer that they should or they have to give those statements weight, and the law is they don't have to give them any weight. So I think the appropriate comment by the court is exactly as the court suggested initially, which is you give it whatever weight, if any, you deem appropriate.
All right, so what I'm going to say is, yes, the videos are evidence. You should weigh the defendant's statements as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, then I'll go and I'll read the electronic communications and the humane practice. That covers it.
I don't have a principled objection to it if the court adds the word "if any,"
I understand.
because I don't want them to think, for instance, the way that it's worded as the Commonwealth suggested it, they have to weigh it the same way they weigh other pieces of evidence. Every single piece of evidence is weighed in and of itself. It's individual to the piece of evidence that's presented. For instance, they could weigh the statements by Ms. Reed. They could give it no weight. Each individual juror could decide, I'm going to dispatch it altogether and give it no weight, while giving another piece of evidence, like whatever that might be, the testimony of one of the ARCA witnesses, complete weight. I think that we need to stress that the clips bear no additional weight, no additional gravity than anything else that they've considered. And the only way to do that is, very simply, you give this the weight, if any, that you decide is appropriate. It doesn't, I think, comparing it and contrasting to other pieces of evidence in the case, it's unnecessary, and it tends to suggest they have to give it weight.
Okay. So your objection's noted. Now let's get to the third one. Does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? What do you want to say, Mr. Jackson?
Your Honor, I appreciate the effort that the court went to amend the verdict slip as it relates to count 2, and I think there are some excellent suggestions by the court in the verdict slip. By and large, I think question number 3 is answered by the amendments in the verdict slip. So we certainly could say something like, does convicting guilty, the question was, quote, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? The answer is no, obviously. And perhaps we could formulate an answer that says something along the lines of, no, new verdict slips have been provided that will make it more clear, or something of that nature, as well as a decision of guilty on the OUI charge 002, number 5, is an explicit acquittal on the higher charges in offense 002, which is a proper statement of the law. And then there are suggestions that we have regarding the edits that the court has made to the verdict slip. And I'm happy to go over those with you and put those on the record.
Okay, go ahead.
With regard to going from the top to the bottom, just under number 1 reads, not guilty of the offense charged or any lesser included offense. We would propose that the court add the consistent language that it's added throughout the verdict slip. If you, quote, if you find the defendant not guilty of the offense charged or any lesser included offense, comma, stop and sign the verdict slip, period. That's the only place that that language doesn't appear, and I think it should appear.
Okay.
The second is a relatively minor issue. However, under number 2, sub 2, the parenthetical check one or both of the following, I think it should say, just to clarify it further, if guilty, comma, check one or both of the following.
All right, I think I'm going to leave it because it appears only under the guilty.
It appears only on?
Under the guilty. So go ahead, I'll hear you further.
Going further, going under number 3, toward the bottom of the page, in the parenthetical that the court suggested, which we find is excellent, if you find the defendant guilty of the lesser offense of involuntary manslaughter, we would simply add that clause.
So we'd have to add it in all of them.
Correct.
Which makes sense. I think
Correct.
we had it in the first one.
Right.
Okay.
And then moving to page 2, at the top of the page under sub 4, again.
Hold on 1 second.
Of course.
Okay.
We had the same suggestion. It appears that the court is not inclined to give it. If guilty, check one or both of the following, and there's a typo. It says the parenthetical
We
says
fixed it.
check one of. Okay.
Yes, so we changed of to or.
So my only suggestion to that would be to, again, add the if guilty, comma, check one or both of the following.
Okay.
On that page, going down to the bolded parenthetical, same thing. If you find the defendant guilty of the lesser offense of motor vehicle homicide.
Okay.
Moving down under sub 5, the
We still
OUI.
need to say stop and sign the verdict slip.
Right. After the word stop, stop and sign the verdict slip.
Yeah.
And then under sub 5, again, the same thing. We just suggested that for consistency that it say, if guilty, check one of the following of the both. And the final edit would be in the final parenthetical, the last sentence. If you find, I think her should be
Yeah.
changed to the defendant. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1.
Okay.
And those are the edits that we have suggested for the verdict
All
slip.
right. Mr. Brennan?
I don't have any disagreement with the edits.
Okay.
The idea of instructing them on the nuance of selecting one guilty or not guilty, I don't think needs to be explained. I think with the edits, this proposed instruction explains it. Yes.
All right. What I,
I don't have any issue with if you state, if you decide on a lesser included offense does not include the earlier offense. And I'm not sure of the exact language that can be used. I don't think that's necessary, but that is something I wouldn't have an objection to. But I think the form that you filled it out with the edits is going to be sufficient for them to follow.
what do you think about the defendant's position that if you were to find her guilty of operating under the influence, Mr. Jackson said explicit acquittal. I don't like that language. I think if you find it, it means you have found her not guilty of each of the others.
That would be fine with us.
I think it's better if you find her guilty of any lesser included offense. It would not include the higher offense.
All right.
I think that's just confusing.
So what I planned on doing was bringing them out and giving them each a copy of the amended verdict slip, explaining that it really is consistent with the jury instructions I gave them, but walking them through it. So we start from the top and then explain, if you find the defendant guilty, you're done. Stop, sign the verdict slip, and let the court officer know you have a verdict or something.
I prefer that.
I think I'll walk them through it like we do in civil cases.
I don't have any objection to that. The only other thing is the digital instruction.
Yes.
We don't believe that it's necessary. I don't think that we should reemphasize that, and we're not asking for it. That
All
would
right,
be-
so you're waiving it?
We're waiving it.
Okay.
Yes,
All
thank
right,
you.
I will do humane instruction, humane practice instruction. So I need 5 minutes, and Tori, your computer, to amend this if we can, and we'll make copies. So we'll bring the jurors in. Let them know that we'll be bringing them in shortly, Tony. All right, jurors, we're in receipt of your question. We've been working on making sure that the answers we give you are the right ones, so it's taken us a while. So the first question, what is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The answer to that question is that you folks have all the evidence. And remember, it's only you who decide the facts in this case. All right? That's the answer to that question. You are the fact finders. The second question, are video clips of Karen's interviews evidence? How can we consider them? Yes, the videos are evidence. You should weigh the defendant's statements in the videos as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, Before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made and that she made it voluntarily, freely, and rationally. So that's the answer to that question. So for the third question, does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? So with that, what I'm going to do is I have amended the verdict slip. It's the exact same verdict slip, and it's still consistent with the jury instructions I gave you, but it's a little bit easier for you to follow. And for purposes of going through this, we'll go through it together, and I've got a copy for each one of you, okay? All right, so you'll see it really is the same verdict slip, but we've added a little bit of language to help you follow it through. So the first charge, manslaughter while operating a motor vehicle under the influence of liquor. So first, in the above entitled case, we say the defendant is, 1, not guilty of the offense charged or any lesser included offense. If you find the defendant not guilty of the offense charged or any lesser included offense, stop and sign the verdict slip. Now, then you go on to guilty of the offense of as charged, manslaughter while operating a motor vehicle under the influence of liquor. Check one or both of the following: manslaughter while operating a motor vehicle under the influence of liquor and or manslaughter while operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of manslaughter while operating a motor vehicle under the influence of liquor, stop and sign the verdict slip. That means on each one, when you stop and sign the verdict slip, that means you have a verdict on this indictment. So stop and sign the verdict slip. If you find her not guilty of manslaughter while operating a motor vehicle under the influence of liquor, then continue below to the lesser included offense. And first, under 3 is involuntary manslaughter. If you find the defendant guilty of the lesser included offense of involuntary manslaughter, stop and sign the verdict slip. If you find her not guilty of involuntary manslaughter, then continue to the next page. Guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence. And you have to check one or both of the following: motor vehicle homicide under the influence of liquor and or motor vehicle homicide by operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below to the guilty of the lesser included offense operating under the influence. And you check one or both of the following: operating a motor vehicle under the influence of liquor and or operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of operating a motor vehicle under the influence of liquor, then stop. If you find the defendant guilty, you stop and you sign the verdict slip. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1. And remember, your decision must be unanimous. All right, does that make it any clearer, hopefully? All right, so with that, I am going to send you back out.
Before the jurors are sent up,
Sure, why don't you come on over? I heard heard myself say this, and I'm glad counsel told me I did. So if you go back and look at the form after 4, if you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony, OUI, liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below. I think I said, then find, I don't know what I said. I heard myself read the guilty of the lesser included offense. So if you find her not guilty of motor vehicle homicide under the influence of liquor, then you continue to decide whether the Commonwealth has proven to you beyond a reasonable doubt that she's guilty of operating under the influence of liquor. And if they have not, and if you find the defendant not guilty on this offense and all other offenses, then you go back and check the first box. So you follow it from the top to the bottom in this manner. Okay? Thank you very much. We're going to release you.
All right, please. Here's all of you.